to start this this education day for our family transitions, and more than excited to introduce you to Sarah Cohen, who is going to enlighten us on fertility law, which of course is a pretty fascinating area. And she's going to give us some background and all across things, as well as giving us some insights as to, you know, how this might impact clients that we're working with as well. So I'm going to turn it over to Sarah and let her teach you guys everything she knows.
Lovely to meet you all. Thanks for having me. I am going to try to share my screen right now. I'm just warning you, I'm technologically inept, so you might have to give me one moment. Oh yes, as you can see, that's not working. Give me 1 minute. Nope. I apologize. I actually am going to ask Linda. I know that's not what we wanted, but do you mind playing my slides? Because
Sure.
I can't figure out how.
Sure, just a sec.
Thank you.
Up and going. Okay. So how is that looking okay for
That's
people?
perfect. If you just go to slideshow, or I
Okay.
wonder if I can, that would be perfect. Is there a way for me to touch this as well while you're doing it?
Because you're co-host, oh, you know what? No, I think it only works. I thought I am on slideshow. Why is that not behaving?
So if we just go to, there you go. Slideshow there, that should be fine. All right, so I apologize, as I said, I'm technologically inept, although I'm lucky enough to do presentations very frequently about fertility law. So I'm going to switch to the next slide, and my name is Sarah Cohen. My practice is Fertility Law Canada. I'm a fellow of the Academy of Adoption and Assisted Reproduction Attorneys. Very briefly about me, I'm on the board of directors of Canadian Fertility and Andrology Society, past president of Fertility Matters Canada, adjunct professor of reproductive law at Osgoode Hall Law School. This is the only work I do all day, every day, and I've been doing it for 12 years. So we're going to talk next. Oh, by the way, I'm terrible at answering my phone, so I haven't even given you my telephone number. But if you ever have questions, I love talking everything fertility law, so just drop me an email. I'm lucky enough, as I was telling Linda, to be totally fascinated still by this practice area, and really I'm quite friendly and happy to chat. So we're going to talk about some terminology in case people aren't as familiar with even fertility processes in general. So I'm actually going to go a little out of order here. So a gamete is a fancy way of saying an egg or a sperm. Ova or ovum is a fancy way of saying a female egg. An embryo is when that egg is fertilized by sperm. IVF is when the doctor or the clinic basically removes one or more eggs from a female body, inserts, either puts in a petri dish and lets the sperm go into the egg, or ICSI is a process where they directly put one sperm into the egg, and that's how we create an embryo for the purposes of IVF. Surrogacy is a process whereby a person gestates a child on behalf of another person. Almost 95% of the surrogacy in Canada is something called gestational surrogacy. And that means the person who is a surrogate on behalf of the intended parent or parents is not genetically related to the surrogate. So that can only happen through IVF, and either with the parents' egg and sperm, or donor egg and sperm, or donor egg and donor sperm. The Assisted Human Reproduction Act, I will also refer to as the AHRA. It is the federal legislation that deals with fertility law across Canada. That part is federal, and as you'll see when we talk about certain things like parentage, those things are actually provincial. The Section 8 consent regulations actually have a new name that's much longer and unnecessarily so in my opinion, but I'll refer to it as the Section 8 consent regulations. For your purposes, they are the most important regulations that you need to be familiar with respect to the Assisted Human Reproduction Act. And the last point here is multi-parent family. And I'm referring that to two different ways. Either it's something like a polyamorous family or 4-parent family. So they may or may not be sexually intimate with each other. They may or may not be romantic partners. And I'm also referring to a multi-parent family in a perhaps it's the wrong terminology. It's where 2 or more people come together and don't cohabitate and actually have a child and intend to have a child between them through fertility processes. So my next slide talks about what is fertility law, and it is, here's my little Venn diagram, and it's kind of an intersection. So is it family law? Not exactly. Is it health law? Not exactly, but it certainly touches on both of those most of the time. But I'm also dealing very frequently with human rights issues, immigration issues, and wills and estates issues, okay? And the next slide shows you that fertility law is divided into federal law and provincial law. And we'll talk about the differences in a moment. I apologize, but I have focused most of my provincial law on the province of Ontario. That's partially because I live in the province of Ontario. That's because every province has different laws when it comes to parentage, although not different laws when it comes to human reproductive material or embryos. Also, Ontario probably has the most up-to-date legislation in the country, and many of the other provinces, one at a time, are updating their legislation. So most recently we had Manitoba update its legislation. Right before that we had Saskatchewan update its legislation. Prince Edward Island updated its legislation. So most of them are really following or the ones that are changing. So Nova Scotia and New Brunswick, for example, haven't changed in a long time, but the ones that are changing are really following Ontario. And that's, I think, a good thing, because although it's not perfect legislation, we'll talk about it soon, it is the most non-heteronormative legislation in the country. So non-heteronormative being there's not an assumption that it's a man and a woman having a baby. And it's also really updated with respect to third-party reproduction. So the principles of the federal legislation, I'm in the Assisted Human Reproduction Act, the principles are set out in Section 2. And I want you to keep these in mind as we're talking about fertility law. And the reason I want you to keep them in mind is I want you to think whether or not we actually achieve these goals. And I would argue that we often do not achieve these goals. So parts of Section 2, I've set out 3 of the principles. One is that women are more affected directly and significantly than are men with respect to assisted human reproduction, that the principle of free and informed consent must be promoted and applied, and that persons who seek to undergo assisted reproduction must not be discriminated against, including on the basis of sexual orientation or marital status. As you can see, in particular, I would say C and E, I don't think we're achieving those very well. I should also mention that a very large part of my clients is made up of the LGBTQ group. And I think that makes good sense, because often between them, they are missing a gamete or a type of gamete, and may also be missing a uterus between them. So the next slide is just going to give you a concept of how the legal framework works. So as I mentioned, the Assisted Human Reproduction Act is the federal legislation. There was, if you're a law nerd like me, I find it fascinating, the decision by the Supreme Court of Canada called the Reference Re-Assisted Human Reproduction Act. It's a very long decision. But what basically happened is Quebec challenged the federal government and said, hey, a lot of this legislation has nothing to do with criminal activity. And the Assisted Human Reproduction Act is basically holding on to its powers by using criminal powers. As you know, we're a federation. And Quebec said, hey, this has nothing to do with criminal activity, but parts of it have to do simply with health, which is under the jurisdiction of the province. And they were successful on many accounts, although it's an amazing decision because it was really went both ways. Now, there are 3 sets of regulations right now to the Assisted Human Reproduction Act. The Section 8 consent regulation, we are going to talk a lot about today. Section 12, reimbursement related to assisted human reproduction, we'll touch on more out of interest sake. And finally, the safety of sperm and ova regulations. Those are really medical processes, so you don't need to know them. But provincially, it's very important to understand that parentage laws differ province by province. And that's true whether they're found in something like family law statutes, the Vital Statistics Act, the Children's Law Reform Act in Ontario, etc. And these pieces actually all fit together. And often you must look at various statutes to understand the entire puzzle. But we also need to think about things like Healthcare Consent Act, Personal Health Information Protection Act, common law with respect to healthcare, etc., and always human rights legislation. Okay, so the next slide shows you, probably if you know almost nothing about fertility law in Canada, you may have heard through the grapevine that it is illegal to pay a surrogate in Canada. And that is true. We'll talk about what that looks like shortly. It is also illegal to purchase, offer to purchase, or advertise the purchase of sperm or ova from a donor or a person acting on behalf of a donor. So it's illegal to buy eggs or sperm from a donor. I should let you know that before this law came into effect in 2004, we had many, many sperm banks across Canada. When this law came into effect, they all closed down one at a time. Currently, there's only one federal sperm bank in Canada, and that's REPROMED in Toronto. REPROMED, because you cannot pay the donors anymore, and they used to be paid like $100, $150, but because you cannot pay the donors anymore, we literally have like 20 to 30 donors per year, and that's it to basically satisfy the needs of the entire country. This is obviously very problematic because we're using the same gametes again and again and again. So many donor conceived people are actually related to each other. And we import about 95% of our sperm from the United States in order to get around this legislation. We also import about 80% now of our eggs from the United States in order to get around this legislation. Eggs, we really have new technology to freeze eggs that wasn't available before. And for a very long time, we've been able to successfully freeze sperm. So that has been available for quite a while. So another thing that is prohibited shows you on the next slide, which is called the Section 8 consent regulations. We're going to talk about those very in much more detail. But Section 8 here, we're not looking at the actual regulations yet, but what Section 8 says. So 8.1 is basically you can't make use of human reproductive materials, that's eggs or sperm, to create an embryo unless you have written consent. And we will look at what this consent looks like. It is not typical consent that you would see with respect to kind of regular medical consent. So if you are, I don't know exactly what your practices look like, but if you are dealing with clients who have reproductive material that is stored, this is going to be very important. 8.3 is about making use of an in vitro embryo for any purpose. And again, it's going to talk in very long detail about consent. 8.2, I should have put in here, but I didn't. 8.2 is, to me, one of the strangest parts, but we have quite a bit of case law on it. 8.2 is that you cannot take from a deceased person's body their gametes without already having written consent from them. And again, we'll talk about that a little bit later. So, and this is just an example of how complicated some of the regulations are. So in the consent regulations, it gives you very specific options about what you are allowed to do with gametes. If it is not in this list, the belief is, according to Health Canada, that you can't do anything else. So for example, following a donor's death, you can leave your gametes to whoever is at the time, your spouse or common law partner, but you can't say, following my death, I want to leave my gametes to, my sister to use, or my brother to use, etc. Okay, so the next part is something that I find fascinating. The actual penalty for breaching, I'm just going to go to the next slide if possible. Sorry, Linda. The next, the potential for breaching Section 7, section 5, which we didn't talk about, that's like cloning. And then 6 is the surrogacy compensation, which isn't allowed. 7 is the compensation to gametes, compensation for gametes, which isn't allowed. And 9 is just the age of a donor. If you breach any parts of those parts of the legislation, it is potentially punishable for up to 10 years in jail and or $500,000. The next slide is going to show you that if you breach section 8, which is keeping track and following the exact regulations in terms of making use of eggs, sperm, or embryos, that still puts you liable for up to 5 years in jail and or $250,000. Finally, the next slide shows you that another potential penalty, even if you didn't breach the law, but there are reasonable grounds to believe you may have acted in breach of any professional code of conduct, the minister, so the Minister of Health, can contact your college. And this is obviously very problematic. So for me, I'm thinking about Law Society of Ontario. I'm not sure which colleges you guys belong to, but obviously that's very scary. Anyone going to college is a problem. And then the next slide is going to show you something that just blows my mind. So if you pay someone $100 for their sperm, you are liable for up to 10 years in jail and or $500,000. But I know things like advocating genocide is only possibly punished by up to 5 years in jail. Driving impaired, only punishable by up to 5 years in jail. Obtaining the sexual services of a person under 18, up to 5 years in jail, etc. So for me, this shows how, I think it's just not in balance with the potential wrongs, if you believe there even is a wrong to society, by paying someone $100 for their sperm. We're now going to look into the concept of surrogacy. And surrogacy is a huge part of my practice. I really love it. It's the idea of a person gestating a fetus on behalf of someone else with the intention that that someone else will parent the baby and the surrogate will not. It's divided up in 2 kinds of surrogacy, and most of what we see in Canada is called gestational surrogacy. I spoke about that briefly. That's when the surrogate has no genetic connection to the baby that they're carrying, and that has to happen through IVF or it doesn't work. Traditional surrogacy, a lot of people think is illegal. It is not illegal. Traditional surrogacy is when the surrogate is genetically connected to the baby that they're carrying on behalf of the intended parents, and they do not intend to be parents themselves. So traditional surrogacy can also be achieved through IVF using the surrogate's eggs, or it can be achieved by IUI, or in Canada, you can actually achieve this through at-home insemination, like the turkey baster method, but it can never be achieved through sex. Okay, let's continue. So the relevant legislation dealing with surrogacy, or the criminal provisions about surrogacy, is in Section 8 of the AHRA. And like we said before, you cannot pay consideration to a surrogate mother, offer even to pay such consideration, or advertise that it will be paid. Section sub 4 is really talking to doctors, clinics, etc. You cannot counsel even a person to become a surrogate mother or perform any medical procedure knowing or having reason to believe that the female person is under 21 years of age. So not so often, but probably a few times a year, I find people are really stuck on Section 6 sub 1, and they'll come to me and say, my goodness, my younger sister is willing to care for me. Of course, this will be altruistic. I'm so excited. And she's actually 20 years old. And we have a problem because, for example, a counselor, a fertility counselor, or a doctor might have started just counseling the potential surrogate mother who's under 20, and people forget about this. So this is criminal activity. Now, Section 6 sub 2 and Section,
Sorry.
no problem. Sorry about that. So Section 6 sub 2 and Section 6 sub 3 are for sure the most confusing parts. And I would like to believe I'm one of the most knowledgeable people in fertility law in Canada, and I could not advise you exactly what Section 6 sub 2 and 6 sub 3 mean. So what it says is you can't pay or accept consideration for arranging the services of a surrogate mother. Now, what exactly does that mean? So what we think it was meant to mean is you can't pay someone to match you with a surrogate and basically offer no other services. But it doesn't say that. It also doesn't say that I can't basically have a business where I schedule the appointments for the surrogate. I organize for her independent legal advice. I organize for her counseling services, etc. We do have one case, which I'm actually not going to spend any time talking about today, where criminal charges were sought after one surrogacy agency in Canada, but the parts with respect to section 6 sub 2 and 6 sub 3 about arranging the services of a surrogate mother were dropped. And I believe, we don't know for sure why, but I believe that's because these parts of the law are probably void for vagueness. And obviously you can't put someone in jail when they can't know exactly what it is they're doing. But you should note that there is no prohibition on the surrogate herself for accepting payment. And if we look at the next slide, something that actually has always been allowed, although compensation has been criminal activity since 2004 when this legislation came into force, you have always been allowed to reimburse a surrogate for her expenditures incurred in relation to her surrogacy. Section 12 sub 3 shows us that the only time you can reimburse her for loss of work-related income incurred during the pregnancy is if a qualified medical professional certifies in writing that continuing to work may pose a risk to her health or that of the embryo or fetus. And you'll note that section 3 sub B base and 12.1 says basically this has to be in accordance with regulations. So we didn't have regulations until about 2 years ago. And the next slide is going to show you that this isn't all the reimbursements that are allowed, but Health Canada provided us with a list of things that intended parents, if they so choose, are permitted to reimburse a surrogate without actually acting in contravention of the legislation. So for example, travel to and from the clinic or her obstetrician, etc., legal counseling, psychological counseling, dependent care, products or services recommended in writing by healthcare provider. This is problematic because, for example, if you need I don't know about you, but when I was pregnant, I used a massive pillow to, support myself, which my husband referred to as the Great Wall of China. And if you want something like that to be reimbursed for that, the doctor has to recommend this in writing. And you're not going to go to your doctor for every little thing, and that's problematic. They can cover maternity clothes, insurance. One of the things that people such as myself who are involved in this area got upset about is that this list did not include net lost wages in the postpartum phase. So basically, if a woman was a surrogate, had a baby on Tuesday, one could not legally reimburse her for missing work on Wednesday. So although this is not included in the regulations, and Health Canada's position was that based on the way section 12 sub 3 is written, a statutory interpretation wouldn't allow it. They provided a guidance document, which basically said, we don't think this is in contravention of the law, which is great. The next slide I want to show you is, I think a lot of people see surrogacy as there used to be surrogacy allowed in India. Right now, up until very unfortunate recent events, there was surrogacy allowed in Ukraine, surrogacy in Georgia. I don't mean the US state, but the other Georgia. Before that, Cambodia, etc., Nepal, etc., etc. Surrogacy in those jurisdictions looks very different than surrogacy in Canada. So in Canada, it's altruistic, and not only can you not pay for services, you're only allowed to reimburse her for expenses. These must be proved with receipts. Net lost wages are proved with things like pay stubs, etc. People come to me every day and they ask, could I, instead of paying a surrogate, could I pay for her kid to go to university or her child's private school, or pay off for the number of months her mortgage, et cetera, et cetera? You can't do things like that. And this really has to be very carefully taken care of in order not to breach the legislation to have criminal sanctions possibility. So the next slide is going to show you, one earlier. The next slide is going to show you you know, people ask me all the time, what goes into a surrogacy agreement? Or tell me more about the surrogacy relationship in Canada. And obviously we deal with parentage. So that's first and foremost. We deal with financial obligations that the intended parents have to the surrogate. So for example, just because it's altruistic, this is not free, and it's actually very expensive because one might not consider it if they were pregnant for themselves. However, if you're not pregnant for yourself and you think about all the travel you do, the work you miss, you know, we are allowed childcare coverage, housekeeping coverage, et cetera, if the doctor certifies in writing that you need it. This can actually be very expensive. But the other things we think about are things like, whose body is it? And really, we deal with things in this agreement like abortion, selective reduction, what other kind of testing the surrogate agrees to do if the intended parents so request, certain lifestyle choices, whether it's foods she can eat, activities she can do, etc. But at the end of the day, the true situation is that as long as that baby is in the surrogate's body, she is going to be able to make the decisions, not her. What we want is as soon as that baby is born, the intended parents are able to make the decision about the health of the baby and not the surrogate. Something we deal with all the time in these documents is what happens if the intended parents divorce or separate while the surrogate is pregnant or before the intended parents have taken legal parentage of the child. What happens if the intended parents pass away during the term of the agreement or before they've taken legal parentage of the child? So we think about those and we include these concepts within our surrogacy agreement. Obviously, we worry about things like confidentiality, which people are actually much more open about these days than they were when I started this practice 12 years ago. So there are a lot of forums that surrogates share information about, but there's also Facebook, Instagram, etc. Are they allowed to not only talk about this, are they allowed to identify the intended parents? Are they allowed to put up you know, the ultrasound pictures, etc. And then a lot of the surrogates in Canada, if you think about why they're doing this, they want a relationship with the intended parents. And I'm not talking about caring on behalf of your sister, which happens all the time, or your cousin or your friend. I'm talking about there are surrogates who literally choose to do this on behalf of someone at the beginning is a stranger. And a lot of these people are nurses, doulas, midwives, early childhood educators, teachers, etc. So people that I see who are already in helping professions. And these people want to know that the moment the baby is handed over to the intended parents, that's not going to be it. They are not a parent, but they want to continue contact with the intended parent and the child. So my next slide looks at who are surrogate mothers. And there is empirical evidence that was a study done by Professor Karen Busby from the University of Manitoba's Law School. And she found that most surrogates in Canada are Caucasian, Christian, late 20s, early 30s. Some are university educated. They have modest but not low family incomes and are relatively stable financial situations. Women of color are greatly underrepresented as surrogate mothers. I should have included for you that there is actually a very new study that was completed by Samantha Yee, which basically is in line with this about still who is a surrogate in Canada. Most of them are partnered. So most of them are either married or have a common law partner. And more or less it looks like this. I will also tell you that in addition to the empirical evidence done both by Professor Karen Busby and Samantha Yee, this is my experience. This is what a surrogate looks like in Canada. We're going to jump to gamete donation. Remember, gamete is a fancy word for sperm or egg, and egg can also be referred to as ova. So interestingly, the Assisted Human Reproduction Act deals, and the regulations there too, deals with sperm donation and egg donation in exactly the same way. And that's sometimes a little surprising because, as you can imagine, donating sperm is a lot easier than donating eggs. Donating eggs has quite a bit of risk to it, potentially. We don't actually have any long-term studies on how egg donation affects the health of the donor. We have had egg donors be hyperstimulated during the process and been in the hospital, etc. Most people, from my experience, it goes perfectly well and everything's fine, but it is a surgical procedure. The next slide is going to show you something that I think is really important that people don't always know about. So there are different types of donors. We used to do a lot of anonymous donation. So that's one end of the spectrum. An anonymous donation is what it sounds like. The donor is never meant to be known by the intended parents or the child, and the intended parents and the child are not meant to be known by the donor ever. Obviously, in an age of things like 23andMe or Ancestry.com, I don't really think you can ever rely on anonymity anymore. I'm going to tell you my biggest preference here, and I gently encourage my clients to go down this route, is a known donor. And the reason this is so important, in my opinion, is because if you Google the term donor conceived person or DCP, and donor conceived people do not like being referred to as a donor child or anything like that, you will see that there are quite a number of people who want to know who the donor is. They don't have to be friends, but they want to be able to identify who the donor is. They want to know why they're left-handed, why they have blue eyes, are there other children in the world related to them, et cetera, et cetera. And also something that's very useful when using a known donor is you can contract, with the intended parents can contract with him or her to find out future health information. So not just whatever the donor knows about their health information or their family's health information that day, but they can contract to find out information going forward. So if it were me, I would always want this in the best interest of the child. When we talk about parentage, you'll see though how known donors at some points, and still are in various jurisdictions, more dangerous than anonymous donors. We do have a middle area called open identification. It's also called semi-anonymous or semi-known, depending on the business of where you're obtaining the gametes from. And that looks good in theory, which is basically that it's anonymous until the child's 18. Once the child's 18, if they want to find out who the donor is, they can do so by contacting the agency. The problem for me is you are relying on the agency to exist 19 years from today, which I don't think is always going to be the case. You're also relying on them to still have records and access to who that donor is. So those are all things people need to consider when choosing a donor. The next piece of this, we've already talked about a little bit. You can't purchase, offer to purchase, or advertise for purchase of sperm or ova from a donor or a person acting on behalf of a donor. But I want you to think about this. We know there's sperm banks, we know there's egg banks. Why is it legal to purchase eggs or sperm from a bank? Because it never says here you can't purchase eggs or sperm, you just can't purchase them from a donor or from a person acting on behalf of a donor. And that sperm bank already owns the eggs or sperm. So for example, what we do is most of our eggs or sperm are imported from the United States. As I was mentioning before, in the United States, that sperm bank or egg bank purchases or compensates the donor in advance, and they have retrieved and stored eggs or sperm. They own them for all purposes. Only once they own them for all purposes, and the money from the intended parents is not flowing through to the donor, at that point, the Canadian intended parent may choose to purchase those eggs or sperm from the bank, which is not from a donor or person acting on behalf of a donor. We do lots of other egg donation in particular in Canada, which is not from an egg bank, but actually a person cycling on your behalf. For those purposes, in a moment, we'll look at Section 12, which is the reimbursements again. I also want you to know that it's okay, I won't continue with that, it's not a big deal. Again, the Assisted Human Reproduction Act has very strict requirements with respect to making use of human reproductive material, so eggs or sperm, to create an embryo, and you need that proper consent from a donor before the clinic can make use of them to create an embryo. Also, you cannot have a donor who's less than 18. We can retrieve sperm or eggs from a person who's under 18. So for example, we do that with people who are about to undergo cancer treatment. You can only do that though if you believe that the person who's going to be created from the sperm or eggs is going to be raised by that person. So the next slide is going to show you that the reimbursements, and the slide after that will show you that the reimbursements for a donor, so whether it's an egg donor or a sperm donor, are again in accordance with the regulations. Again, Health Canada only provided us with the information about what you can actually reimburse a donor about 2 years ago. So before that, we didn't have regulations telling us what we could reimburse a surrogate or a donor. So we basically used in our mind the but-for test. So different lawyers dealt with that differently. I'm conservative in my practice of law, so I wouldn't allow my clients to do things like reimburse for rent, because she would have paid that anyways. Same with a donor here. We now have very specific things we're allowed to reimburse her for. Again, net lost wages were never included, and that makes no sense because you can do completely altruistic egg donation. You have your sister in Thunder Bay, you're in Toronto, you fly her in from Thunder Bay to Toronto. The clinic is not going to say, okay, next day go home. They're going to bring her in for a few weeks of cycling and monitoring her, and then they're going to want her to stay for a few days after. So she might miss a number of weeks of work. Why should she not be reimbursed for that, or why should that not be legal? So again, Health Canada said in the guidance document, look, there's a mistake here in the legislation, but we can't do anything about it. So we don't think this is illegal. Okay. Now, I want you to understand that there are two pieces of the puzzle. There's the federal legislation, which is the AHRA, but there's legal parentage, and they both really make up fertility law together about how to deal with human reproductive material and who is a parent with respect to children created or conceived through the use of third-party reproduction. So the next slide is going to show you that province by province, the answer to the question of who is a parent is answered completely differently. One of the things that was the most problematic was using a known sperm donor. And I really didn't like that because, as I was explaining before, I think for children conceived through donor gametes, it's better to use a known donor if we're thinking about the best interests of the child. But many jurisdictions, including Ontario until 2017, right now including some other maritime jurisdictions in particular, there is still a question about whether a known sperm donor is legally the parent. And it was very ugly. And we'll talk about what happened in Ontario. So Ontario now is a very special jurisdiction, and it allows multi-parent families. So we can have 4-parent families. And when we see 4-parent families, not always, but we frequently see a lesbian couple and a gay couple, and they choose to raise a child together. There's also polyamorous families. Ontario is also special in that you can still be a parent of a child born through surrogacy, regardless if there's any genetic connection to you. So you can have donor sperm, donor egg, and surrogate, and you are still able to be the legal parent of the child born through surrogacy. That's not the case in places like Alberta. So it changes jurisdiction by jurisdiction. Ontario and British Columbia are by far the most flexible and open to these concepts. Ontario also allows sperm donation through sex in certain situations, which we'll look at later. I find this fascinating because there's obviously a lot of policy reasons not to allow this, but it is permitted in this situation. And to the best of my knowledge, this was the first jurisdiction in the world that allowed it. Let's look at the next slide. The reason that Ontario changed its legislation back in 2017 is I wish it came from the government's good heart and good intentions, but they were actually a charter challenge called the Grand Charter Challenge was made against the province, saying that there's many children now being born through assisted reproductive technologies. We need recognition of non-heteronormative family building, so LGBT family building. And in particular, it was dangerous for 2-mom families. As I was saying before, the known sperm donor could have been a parent, and it could have been that the non-gestating mother was not a legal parent. And, if, for example, the gestating mother passed away, the non-gestating mother had no rights. And what happens if the gestating mother and the non-gestating mother separated? Who has rights? So this was a major problem. And this was the impetus for the change. So the change we'll talk about in a moment is actually, we can change slides. Actually, is called, it was called the All Families Are Equal Act, but what happened is it really affected the Children's Law Reform Act. And it has a lot of interesting parts. I think I'm just touching on timing of conception here, just because what is going on in the United States, this is really interesting. A child conceived through assisted reproduction is not conceived the day the egg and sperm come together, which is, for example, in the state of Louisiana, that is a person, but they are conceived on the day the reproductive material or embryo is implanted into the birth parent. So very, very important. Another thing that we learned from that, though, is that ART can be anything other than sexual intercourse, although we've talked about sperm donation through sexual intercourse, but really at-home insemination in Canada is perfectly recognized. So that's what I call the turkey baster method. That is not the case in many jurisdictions around the world. Okay, so the next part shows you the biggest change with the Children's Law Reform Act with Section 5 is that a person who provides reproductive material or an embryo if for the use and conception of a child is not and shall not be recognized in law to be a parent. And they're a donor. And this is amazing legislation because makes it very secure to use known donors and anonymous donors. Any donor becomes secure in Ontario. But it's important to remember that Ontario does allow for 3+ parent families. So we need to have documents, contracts in place saying that that's not what we're doing. These are the parents, the donor's just a donor. So if we keep on going, Ontario deals with legal parentage with respect to surrogacy in a way that I don't think is perfect, but is far better than what we used to have. So a surrogate is someone who at the time of conception did not intended to relinquish entitlement to parentage of the child that she was carrying. And this has to happen through assisted reproduction, can't be through sex. Again, there is no legislation anywhere in Canada that distinguishes between gestational and traditional surrogacy. So there's no stronger law for a surrogate who is not genetically related to the child they're carrying than there is for a surrogate who is genetically related to the person they're carrying. So people don't necessarily understand that, but the law is not different in any place in Canada for that. So something that's not great in the Ontario legislation is that the surrogate technically is still the legal parent at the time the baby is born. And if we go to the next slide, sorry, one more. We can see that the intended parent is the other party of the surrogacy agreement. The surrogacy agreement must be in writing. And it must be between the surrogate and at least one person who expects to be the intended parent. In the agreement, the surrogate has to agree not to be a parent of the child, and each of the parties has to agree, the other parties, the intended parents, have to agree to be a parent of the child. The next slide is going to show you that there is a new special process in Ontario, which is great in many ways, but I can talk to you about why it also has some risk to it, which no longer requires intended parents to go to court and go in front of a judge to become the legal parents of a child born through surrogacy. But instead, if 4 things are in place prior to the embryo transfer or the insemination for surrogacy, we don't have to go to court to make the intended parents the legal parents of the child. So the first thing is there must be a written surrogacy in place prior to the embryo transfer or prior to the insemination. By the way, clinics are almost never involved in traditional surrogacy. They don't like it. People do it as an at-home method and generally just to save costs because IVF is a fortune, as you're probably aware. The second thing that has to happen is that all parties have to have independent legal advice, not just the surrogate, but also the intended parents. I think this is very important. As a lawyer, I'm really glad that's there. Also, by having that, I feel for my clients, it's basically like an insurance policy that the surrogate can't say that she didn't understand, she wasn't the parent, and we're all parents together. If you want to just do a birth registration and not go to court, it's only up to 4 parents that can be intended parents. If you want 5 parents, you must go to court, etc. And finally, the child must be conceived through assisted reproduction, not sex, but anything else goes. Okay. Now, if you want to do that process, The surrogate must consent in writing that she's relinquishing her parentage of the child. This has to happen only 7 days plus after the baby is born. In that case, the child becomes a child of the intended parents, and the child ceases to be a child of the surrogate. One of the things I don't love about this is because it permits traditional surrogacy, which can happen at home, we don't know if this is ever going to be basically someone taking over an adoption, which is not the same as a surrogacy. It doesn't anymore require for traditional surrogacy. The parties are the people who say, oh yes, we did all these things. It's not requiring like a letter from the lawyer saying I gave independent legal advice. It's not requiring DNA testing, anything like that. If you need to, though, you still can go to court and get a declaration of parentage for the intended parents and non-parentage for the surrogate. Okay, next slide, please. Okay, so what happens for those 7 days following the birth when the surrogate can't yet relinquish her entitlement to parentage of the child? So this part's awful of the legislation. It says the surrogate and intended parent share the rights and responsibilities of the parent for those 7 days. However, if there's a provision of the surrogacy agreement respecting parental rights and responsibility, after that, it's of no effect after those 7 days. So, you know, you have a bind if the surrogate doesn't sign on the 7th day. Okay. By the way, that was unless the surrogacy agreement provides otherwise. So if you have a lawyer doing a good job, they provide otherwise. Another part of the legislation I don't like is a surrogacy agreement is unenforceable in law. That's lousy. It is proof of intention that the intended parents intend to be a parent, and it is proof of the intention that the surrogate did not intend to be a parent. And our case law in Ontario is all about that intention prior to conception is what makes a parent. So, you know, I'm not sure this was helpful to legislate this. Maybe the jurisprudence was actually better. But I do want you to know that the fact that a surrogacy agreement is unenforceable in law, it's unenforceable by the intended parents, but it's also unenforceable by a surrogate. Something people who are not in the fertility world would be shocked to hear is that it's not intended parents usually who choose not to take a baby born through surrogacy. Oh, I lied. It's not the surrogate who chooses to be a parent of a child born through surrogacy. It's the intended parents who decide they don't want the child, whether it's because there's a disability, whether it's because the intended parents separate, whether it's because they use donor gametes and now somehow manage to have a child using their own gametes. Those are the situations we've seen in Canada. We really haven't seen a gestational surrogate ever try to keep a baby. Okay, next slide, please. So again, something that's very special about Ontario legislation is it took out words like mother, father, male, and female. So it is friendly really to everyone. It also says some important things for spousal relationships. If the birth parent of a child conceived through assisted reproduction had a spouse at the time of the child's conception, the spouse is a parent of the child. If the birth parent of a child conceived through insemination by a sperm donor had a spouse, the spouse is a parent of the child. And the next slide, please, will also show us something interesting. One more up, please. Just a little higher. Yeah. What happens if the birth parent doesn't have the consent of their spouse before the conception and goes ahead and gets pregnant using assisted reproductive technologies anyways? If the spouse did not consent to be a parent of the child, or the spouse consented to be a parent of the child but withdrew consent before conception, then they are not a parent of the child, okay? And now we can talk about the next slide, please. When it comes to multi-parent families, this can happen through sex or through assisted reproductive technology. So for example, you can have a polyamorous family and, you know, maybe 2 women and a man, and 2 of them have sex together, have a baby, but all 3 intend to be the parents prior to that conception. As long as you have that pre-conception written agreement in place between all of those parties, they can be registered, all 3 of them, or it could be 4, as the intended parents of that child, okay? And again, it's up to 4 without needing a court application for parentage. If you want 5, 6, 7, you perhaps could do that. I've never seen more than 4 without, you could do that by going to court technically, okay? And the next slide, please. I just find this fascinating. You can do sperm donation through sex. This was new legislation. This was the first place in the world, to the best of my knowledge, that allowed this, but there must be an agreement in place prior to that sex happening that the donor does not intend to be a parent of the child. And then that donor is not a parent of the child, and they don't have any of the rights or obligations that go with being a parent of that child. You know, the case law that came out of these changes to the Children's Law Reform Act, unsurprisingly, were all about this part, because, you know, at some point people had entered into a verbal agreement, even though this requires in writing, and the court said, well, you had an agreement that the donor was just a donor, even if it was through sex. In another case, there were people who had an agreement, and they were exes, but they kind of started getting back together while they kept on having sex. And this went on for like 8 months. And the mother said, you know, we originally had an agreement, but the relationship changed. We were now a couple again. And the court said, no, you had this original agreement. So this is confusing, and I'm not sure it's the best idea there. Okay, next slide, please. Posthumous conception under the Children's Law Reform Act. So we do see this sometimes. A person who at the time of deceased person death was his or her spouse, and the term spouse is important here, so it doesn't have room for polyamory, etc. May, or arguable, may apply to the court for a declaration. Right, was there a question there? Okay. You can apply to the court after his or her death. If the child was conceived through assisted reproduction, it has to happen after the child was born, but no later than 90 days after the birth, although the court can extend that time. The almost strange part here, though, is the deceased person had to consent in writing together with the applicant to be a parent of the child conceived posthumously through assisted reproduction. And how many people actually consent in writing that if they die, I have embryos in storage or sperm in storage, I intend to be a parent of that child conceived through assisted reproduction if I die. So that must be in place in writing in order to benefit from Section 12 of the Children's Law Reform Act. The next slide, please. I'm not going to go into detail here, but this affects the Succession Law Reform Act. And again, the next slide, please. Again, this is all having to deal with assisted reproduction, embryo, reproductive material, the baby has to be born within 3 years, et cetera, et cetera. Okay. Sorry, and I'm just going on about supportive dependence, which I'm not going to go into detail for you. And finally, what I really want to talk to you about, and kind of was setting up here, is the Section 8 consent requirements, because I think this will be really interesting for your clients when they are coming together to create families or breaking up families, and what happens with reproductive material or embryos. So the next slide is going to show you Section 8 in the Assisted Human Reproduction Act is divided into 3 parts. One of them is what consent is required to make use of HRM as human reproductive material. So that's gametes, gametes to create embryos. What consent is necessary to remove human reproductive material from the body of a deceased in order to make use to create embryos. Oh, sorry, to use embryos. Oh no, to create embryos. I'm sorry, I got confused there. And what consent is required to make use of those embryos. So the next slide is going to show you that I actually think this took me about 2 years to understand these 15 pages. And those 15 pages are necessary to explain 3 sentences, those 3 sentences basically that we looked at earlier. They are extremely confusing, extremely overwhelming. Health Canada takes very strict interpretation of this. You have to have both a document explaining everything and a document where consent is provided. And it also has to provide all potential purposes, even when they're completely irrelevant for the situation, or Health Canada says that the requirement has not been met. It must be witnessed, and consent may be withdrawn. It has to be withdrawn in writing and at different times for different purposes. So consent regulations are going to be, they're very, very difficult. You may be looking at consent forms for your clients. I don't know if you do that. It will be, there is some litigation about what happens if couples or families split up. And sometimes it may come down to the consent regulations, and we'll talk about what case law says about sometimes it not coming to those consent documents. So these are some definitions with respect to this consent to use. So a common law partner can only be an individual. So this doesn't really work with polyamorous families, and they are cohabiting in a conjugal relationship at the relevant time for at least 1 year. Third party is never, it's okay. A third party is never the spouse or common law partner of that donor. And okay, and it could be a couple of whom neither the spouse or common law partner is the donor. And that is with respect to sperm or eggs, but with respect to an embryo, a third party is an individual who's not the donor. So their gametes were not used to create the in vitro embryo, and it could be a couple again. And the reason I've highlighted things like couple or spouse or common law partner is think about what this means for multi-parent families. It doesn't work. Okay, so next part. Spouse does not include a person who at the relevant time lives separate and apart from the person to whom they are married because of the breakdown of their marriage. And as you saw before, common law, they must be living in a conjugal relationship for at least 1 year and living together at the relevant time. So the next slide, I'm just trying to show you the various parts about the consent to use human reproductive material to create an embryo. You have to have a document signed by the donor, and the donor's definition here is the person from whom the reproductive material was retrieved, and they get to choose how they get to make use of the human reproductive material to create an embryo. It can only be used for their reproductive use for basically the list that's provided here. It can't be used for any other purpose. So their own reproductive use. Following their death, the reproductive use of the person, so one person, who at the time of their death, their spouse or common law partner, the reproductive use of a third party, and then certain medical uses. However, you can't basically put in a will that I donate my sperm that is frozen at a clinic because I have cancer to my younger brother or older brother to make use of in conception of a child, etc. So people get very upset about this, that you cannot bequeath your reproductive material after your death to anyone other than your spouse or common law partner. So the next slide, if you are, if it's used to create embryos for reproductive use of the person at the time of your death, if there are extra embryos, this has to be used in accordance with the original person who died. No, it has to be used in accordance with the spouse or common law partner's consent. So you have to understand that they get to decide what else happens to them. If it is created for the use of a third party who is a couple, along with the human reproductive material from an individual who's a spouse or common law partner in the couple, it's subject to consent of that individual alone. If prior to the use, that individual is no longer a spouse or common law partner in the couple, and we'll talk about that later and how that really tends to affect women and LGBT couples. Okay. Now, I think you'd be surprised how much comes out of this, or I'm always surprised with this. There is consent required to remove human reproductive material from a donor's body after the donor's death, donor being the person who has the eggs or sperm. Never seen this happen with eggs. I'm not sure we're at a place where medically that could happen, but we are at a place where sperm could be removed from a person who has sperm's body post-death if it's done quick enough. And the hard part here is you need in writing the donor's consent to remove it from their body and to create an embryo for just the purposes listed. Again, the donor's spouse or common law partner, and then other reasons which are medical in nature. So there is case law on this, which we'll look at in a moment. And the next slide, again, it's really talking about the same thing. You must have, sorry, just jump up one more. Thank you. You must have the donor's written consent. And who has written consent? If I die, you can remove the sperm from my body for my wife to make use of the sperm to create embryos for her reproductive purposes. So that's, you know, it doesn't really make sense because who does that? Okay, next slide, please. One you are going to be dealing with, I think, or I deal with, is who is allowed to make use of embryos once they are created. In this part, donor doesn't mean whoever's material was used. The donor is for whom the embryo was created. What happens if they are spouses or common law partners at the time it is created? They are considered the donors. If they are a couple, the embryos can only be used if both spouses or common law partners consented. However, if they are no longer spouse or common law partner in that couple, it is only the person who is genetically related to that embryo whose consent is necessary to make use of that embryo. Okay, let's continue. Thank you. And again, there has to be documents signed in accordance with some very long regulations. The problem here is if the donor wishes to withdraw their consent, the withdrawal must be in writing. And the withdrawal is effective only if the person who intends to make use of the in vitro embryo is notified in writing of the withdrawal. And the problem is I see a lot of heterosexual couples where, for example, maybe there was a woman who was going through cancer treatment and they retrieved eggs right before she started chemotherapy. They made embryos. Embryos freeze so much better than do eggs. So the doctor is probably going to suggest that they make embryos as opposed to just freeze her eggs. And then they break up. She cannot make use of those embryos without the consent of her husband, ex-husband or ex-spouse, ex-partner. And because both of their genetic material is in it, she has no right to the use, and he can stop her at any time. And he does stop her very frequently. And often these women can't make embryos again. They're now too old. As you know, probably fertility for women goes much faster than it does for a man. This is also true with LGBT couples in the sense where if only one of them is genetically related, and that's what always happens, if they're cisgender LGBT couple, only one of them is genetically related to the embryo, it's only that one person who can make use of the embryo, not the other one. So this slide shows you how many assumptions are in these ideas under the Assisted Human Reproduction Act in terms of who can make use of reproductive material or embryos. So first of all, it's very heteronormative. It doesn't really represent LGBT parents, kind of the way I just explained. It does recognize single parents though. It makes an assumption about marriage or common law. It doesn't really make room for people who are creating families together but do not live with each other and don't have a romantic relationship. So it doesn't really work that well. It assumes they live together, it assumes conjugal relationship. It doesn't really work for polyamorous families, multi-parent families. It talks about couples or individuals or spouses. It assumes at most two parents. the regulations aren't clear about what happens where no one of the two people in a couple are genetically related to the embryo they've created, who's allowed to make use of it, whose consent is necessary. We'll see case law on that. And again, it doesn't recognize that you might have more than one partner upon your death, and you might want to leave your sperm to both partners, and you aren't able to do that. It only talks about one individual. So if we go to the next slide, this is kind of what I already talked about. If it's a polyamorous family or more than two parents, one person is always not genetically related to the embryos, and they're at a huge disadvantage. They don't get to make use of the embryos. They may have paid to create the embryos, but they can't use them. And again, punishable for a doctor or a clinic up to 5 years in jail or $250,000 if they do this without the proper consent. Again, it uses terms like divorce or separate. That doesn't happen if people aren't romantic or conjugal partners, but choosing to create families together. And as you noticed before, under the provincial legislation, it considers 3-parent, 4-parent families. It considers people coming together to create families where they are not genetically related to each other. And they're not in a romantic relationship with each other. They might not even live together, but they are creating embryos or through assisted reproductive technologies. And again, it doesn't allow people with more than one romantic partner to leave their gametes to more than one partner because it uses the term individual. So let's go on. As I was saying, it contradicts often, not always, it contradicts provincial legislation. And this is a problem. They do not work together. So let's look at what happens if a couple separates. And in this situation, we need to think about various things. We need to think about the consent to make use of human reproductive material. So that's eggs or sperm. What happens if it's my reproductive material, which, maybe my husband went through the process to pay for with me, but it's my eggs? What happens if it's his sperm? And then what happens if maybe we're a 2-mom family and we've purchased donor sperm, which isn't genetically related to either of us? And there is case law on that. And the consent to make use of embryos is a little bit more complicated. There's what if it's the reproductive material of both partners? What if it's one partner's reproductive material? And what if it's both donor sperm and donor egg whose consent is necessary if they separate in order to make use of the reproductive material? Again, if they're still together, the embryos you need both people's consent to make use of the embryos. The question really is if they separate or divorce. Okay. So the first case that's on this was a BC case called JCM and ANA. There was a 2-mom family who purchased sperm straws from a sperm bank. They together had 2 children using that donor sperm. They broke up, but they had 13 straws of donor sperm left. One of the moms wanted to use the sperm with her new partner to create another child, so that new child would be genetically related to her existing children. And the other mom said, no, I want to destroy the sperm. I don't want you to be able to create more children who are genetically related to my child. And the court held that this was property. And the straws of the sperm were split between the exes as equally as possible. The court could not concern themselves or even talk about the best interest of future child with respect to the biological link to siblings. That is not what the decision was made on. It was simply treated as property upon marital breakdown. And the court was never swayed by the argument that treating sperm as property commodifies human life. Okay, and the next slide is, there is no case law on what happens if it's your own sperm or your own eggs, and we assume it's just because under the Section 8 consent regulations, you are the donor, you get to decide what happens with your sperm or eggs, whereas that's not property, we don't believe. The property part is what happens if we're not genetically related to either, and we've purchased sperm or eggs. So the next slide will show you that there are frozen embryo disputes. There were these cases in Canada from about 2012, and we didn't have decisions yet. Things were decided basically behind closed doors. So we didn't have court decisions yet, but we now have some court decisions that are with respect to the Section 8 consent regulations and not just general property that has nothing to do with the Section 8 consent regulations. So if we look at the first case, it's the Genesis Fertility Center case. In this situation, there was a man who we knew he was dying. He had cancer. He had cryopreserved sperm. When he signed the consent forms at the clinic, there was no option to say, if I die, I want my wife to be able to use a sperm to create children. So contrary to the written requirements of Section 8 and its consent regulations, there was no written consent, but the court held there was enough oral consent given to satisfy the objectives of the Assisted to and Reproductive Act and allowed the wife to make use of the sperm. The next case, though, arguably overturns this. What happens here is actually not under Section 8.1, which was the first case, but Section 8.2. In this case, there was a young married heterosexual couple and the husband died suddenly. He had no will in place. He had no written consent that his wife could have the sperm extracted from his body if he died so that she could create embryos and have a child born posthumously from his sperm. So there was no written instructions to that. There was no consent. So that was in breach of the Section 8 regulations, or at least it wasn't in accordance with Section 8 regulations. So the court at first instance did allow the removal of sperm because there's an emergency order. You don't have much time. It's kind of now or never. So they allowed the removal of the sperm, but they then did not allow the wife to make use of the sperm to create embryos. This went to the Court of Appeal, and the Court of Appeal was actually really sorry for the wife and didn't like this, but they said Section 8 consent regulations deal with this. It says specifically, unless the donor of the material gave written consent to this, and who would give written consent to something like this, you can't use this material. So the wife, unfortunately, was never allowed to make use of the material. And the last case is the leading Ontario case, which also went to the Court of Appeal. In this case, there was a cis male and cis female couple. They had a child together. They didn't use his eggs. They didn't use his sperm. So they made embryos using donor eggs and sperm. They actually did this in the United States somewhere. They had one embryo left over. They already had a child together, but they had one embryo left over and the female wanted to use it. And the female looked at consent forms where the male had said, if they split up, the wife can use it. And the argument was basically, this is a contract. The husband or ex-husband said, go ahead, use the embryos. And now he'd contracted that and she was allowed to rely on that. But they didn't even look at the section consent regulations or the All Families Are Equal Act, who is a parent, who's not a parent, whose consent is necessary. And the Court of Appeal overturned this decision and said, unfortunately, the ex-wife is not allowed to use these embryos or this one embryo because it's kind of weird. If you switch slides, I'll show you what happened here. Oh no, I didn't put it there. Sorry, don't switch slides. I apologize. But what happened here is the court is basically the legislation or the regulation is very clear that if you split up, we need both people's consent to make use of the embryo, except where only one person's reproductive material is used. So this was interpreted to say, back to the first one, we need the consent of both of you because neither of your reproductive material was used. And then the last slide I want to talk to you about is, what does Health Canada say with respect to the use of embryos if it's a polyamorous family? And what they say is, and I asked them, do you need the consent of all the people, if they are still together, for whose reproductive material, basically to make use of an embryo where obviously only two people's reproductive material was used? Do you need also the consent of the third person because the embryo was created for all three of them? And they said no, because the way the consent regulations read, it's only for an individual who has no spouse or common law partner or a couple. So it can't.
Well, if I have any issues, I'll give you a call right back.
Oh,
Thanks.
please mute yourself.
So it doesn't work with polyamorous or multi-parent families. And then what happens if you have two people who intend to co-parent but are not spouses or common law partners, so no conjugal relationship, don't live with each other, etc. And they said in this case, if they split up, but there is no splitting up, right? Because there's no divorce, there's no separation, you still require the consent of each individual. So that's Health Canada's interpretation, and they have talked to me about this. The federal legislation and regulations does not consider the kind of things that are considered in terms of family building by the provincial parentage laws. And this is the end of my presentation. If you do have questions, please feel free to email me. Always happy to chat, and I'm open to questions if you have some.
Okay, so where's the audio on this?
So based on what you talked about, one of the questions I have is, because there's the federal and the provincial, which one does sort of control things under, you know, if people are separating, divorcing, or coming together, being as if it's being considered property, is it only provincial that would be in charge?
That's a great question. So no, it would be federal if you have human reproductive material stored. So for example, in the JCM and ANA decision, you have a 2-mom family. Obviously, they need donor sperm to create their family. They bought donor sperm from an American sperm bank, had it stored. That was property. Embryos are dealt with, and human reproductive material that is from my body is dealt with differently. It's up to me. It's not joint property in the marriage, okay? Embryos that we've created in a marriage or a common law partnership are, if we break up, are dealt with differently depending on who is genetically related to the embryo and who's not. An important point in the SH decision is that any contract that tries to get around that is going to be unsuccessful, because the legislation or the regulations to the legislation would override it, because it already tells you, you know, if I enter into an agreement with my husband, we make embryos, and in that consent form, he says, if we divorce, I'm allowed to use them. Well, the Section 8 consent regulations say, no, I'm only allowed to use them if he consents to and does not withdraw his consent. The parentage part is different, because that's, you have a child who's already gestating. Once their child is gestating, if we are still partners, regardless of the genetic connection, if the child is gestating at that time through assisted reproductive technologies, we're both parents of that child. Doesn't matter who's genetically related. Doesn't matter who gestates the child. If it's used after we break up, different about who is a parent.
So based on what you're saying, pretty important if people are doing cohabitation or marriage agreements to speak to someone like yourself if they are looking at using reproductive fertilization or whichever different way they might do things.
Certainly, and I think that perhaps the only place where an agreement would certainly be withheld, certainly be held up, would be that donor material and like the 2-mom family or the 2-dad family, or whichever family is using reproductive material that's not genetically related to either of them. You treat that as property. So, you know, that one for sure we're going to be successful in terms of who gets it if you divorce or separate. People care that their children are genetically related to each other. They really do. It's a big deal to them.
Mm-hmm. Really interesting. Anyone else have any questions?
My question is content.
Oh, we can't hear you, Gail.
Okay, my mic is on. Okay. You can't hear me?
Oh, now we can.
Okay, because my mic is on. Will that PowerPoint presentation be provided to Linda? No, because that's a lot of information.
Yeah, I will be sending it out to people. Yeah, you're right. It is a lot of information, and some of it I think is quite interesting for us. And yeah, to figure out which pieces it would be good to go through the PowerPoint for sure. So obviously a fairly packed situation. Anyone else have any questions? Oh, Joanne has her hand up.
I can't hear you, Joanne, unfortunately.
Oh, I do have a question in the chat that says, is if the genetic material is imported from the US, are they considered American for the purposes of taxation?
That's actually a great question. And I'm going to tell you to some extent, I don't know. We know that if a baby born through surrogacy to Canadian intended parents in the United States, they are subject to US taxation, and that can be very problematic. My clients, the only ones who do surrogacy in the United States, are extremely wealthy to the point where you probably would know their last names. And they do consider the issues of taxation in terms of having children born in the United States. If the gametes are imported from the United States and the baby is born in Canada, certainly they're Canadian citizen, but it really remains to be seen if that sperm donor could pass on US citizenship to the child. And I don't have a good answer to that, but I think it's fascinating.
Yeah, that certainly would be. Joanne? Oh, we can't hear you. You're on mute. No, we can't hear you now. I still see you as being on mute. Okay. Or do you want to write it in the chat? I don't know why you're not coming through.
Joanne, perhaps you can write it in the chat.
I believe she is.
Um,
I don't see it coming through yet, but
So Joanne, are you asking if there is a written agreement between, you know, myself and some gentleman I meet in a bar for a one-night stand, but there's a written agreement that if we have sex, he is not a parent, is he just a donor? And under the legislation, yeah, he's just a donor, has no rights or obligations to that child. This is in Ontario. It is not the same across the country.
does that address your question, Joanne?
I'm sorry if I didn't quite understand. You're welcome to send me an email later. I'm happy to chat about it.
Yeah, it's bizarre because I can see your mic is on now, but not sure what's going on. Any other questions that anybody has before we let Sarah go? Okay. Anyways, of course, she does have her email available. I will be sending out the PowerPoint to everybody so that if there are questions or if you come across a case where this comes up, you'll definitely know who to reach out to. Thanks very much, Sarah. I think this has really been an information-packed session, given us lots of food for thought, and we certainly appreciate you taking the time to work with us today.
Thanks so much, Linda. I really enjoyed it. I appreciate your time.
That's great. That's great. So I'm going to give everybody their break a little bit early then, and our next presenter is at 12:45. So you can just go do whatever you need to do for a few minutes, and we'll resume at 12:45. Thank you.